This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why sexual abuse of a child is always excluded on a liability insurance policy and why the courts of Washington State made it obvious that a clear and unambiguous exclusions for and against abuse of children must be enforced, and why abusing a child can never be fortuitous. It is an intentional tort and a crime, and excluded by every possible liability insurance policy, if only by the implied exclusion of fortuity. The Plaintiff Insurance Company sought a declaration that it had no duty to defend or indemnify Jacob Jackson or his wife, Stacy Jackson, for claims asserted against them in civil lawsuits which allege that Mr. Jackson sexually abused and exploited minors. In American Strategic Insurance Corp., a foreign insurer versus Jacob Jackson et al., the United States District Court for the Western District of Washington in Tacoma on July 24, 2024, found that the insurer had proved that criminal charges against Mr. Jackson, including for rape of a child in the third degree, child molestation in the third degree, and communication with a minor for immoral purposes, now pending in the state court, where trial has not yet begun until November of 2024. The insurer moved for partial summary judgment on its claims against Mr. and Mrs. Jackson only as they relate to Jane Doe 20 as guardian ad litem for John Doe 20 et al. Versus Inspirit Athletics et al. And John Jackson. These cases are only one of many John Doe cases against the Jacksons, most of which are being resolved by motions for summary judgment and are pending in state courts. The plaintiffs only issued a homeowner's insurance policy to Mr. and Mrs. Jackson. This primary policy was in effect between September 16, 2019 and 2022. In addition to the primary policy, the plaintiff also issued an umbrella liability policy to the Jacksons, and the plaintiff accepted defense of the civil lawsuits at issue for the Jacksons pursuant to a reservation of rights. It then sued, seeking a declaration that it owes no duty to defend or indemnify the Jacksons for any of the claims asserted against them in the John Doe 20 lawsuits. According to the complaint filed in the John Doe 20 lawsuit, Mr. Jackson was the head of a boys' basketball coach for Sumner High School, located in Sumner, Washington, from 2016 to 2022. Mr. Jackson is also alleged to be the CEO of Inspirit Athletics, Inc., a sports equipment manufacturing and marketing company. The John Doe 20 lawsuit contended that Mr. Jackson met John Doe 20 when he was around 10 years old, and over the next several years showered him with attention and gifts of athletic equipment, sterling clothing, and gear. Mr. Jackson socialized with the family, and while John Doe 20 was in the Jackson's closet, Mr. Jackson stripped naked, cornered John Doe 20 in the closet, and began masturbating in front of John Doe 20. Mr. Jackson then allegedly forced himself on John Doe 20, grabbing his genitals and masturbating John Doe 20. The John Doe 20 lawsuit makes claims for sexual exploitation for children and false imprisonment against Mr. Jackson on multiple occasions. The insurance policies were two: one, the homeowners and its umbrella Both policies excluded bodily injury arising out of sexual molestation, as well as bodily injury resulting from any illegal or criminal act performed by or at the direction of or in conspiracy with any insured, and this exclusion applies regardless of whether the insured is charged with a crime. The umbrella policy also contains several exclusions that the plaintiffs maintain are relevant. For example, it excludes bodily injury and personal injury unless such liability is also covered under the applicable underlying insurance, the homeowner's policy. The umbrella policy excludes bodily injury which is expected or intended by an insured, and bodily injury and personal injury arising out of sexual molestation, corporal punishment, or mental abuse. In Washington, an insurance policy is construed as a contract and given fair, reasonable, and sensible construction as would be given to the contract by an average person purchasing insurance. The plaintiff's motion for summary judgment regarding the duty to defend should be granted. The plaintiff has no duty to defend the Jacksons in the John Doe 20 lawsuit, neither the primary policy nor the umbrella policy, which only provides coverage if the primary policy could conceivably cover the allegations in the complaint. If there is no duty to defend, and there is not, then there is no duty to indemnify, and therefore the plaintiff's partial motion for summary judgment should be granted, and plaintiff American Strategic Insurance Corporation's motion for summary judgment was granted. In my opinion, liability insurance is designed to protect an insured only against fortuitous acts. Sexually molesting a child can never be fortuitous. It is an intentional act that is both immoral and illegal, and excluded by clear and unambiguous language. The couple should be forced to pay whatever assets they have to the families of the abused children, as well as serve time in prison. Insurance is not designed to make it easy to commit crimes at all, and especially crimes against children. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week. And you'll also have access to the more than 4,800 blog postings. You can also subscribe to the videos on YouTube and rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and the videos, and let them also subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.